Thank you very much indeed, and welcome. Thank you for turning up. As they say, 80% of success is turning up. So thank you. Thank you for Legal Business for making us all come and do this in person. It's great to see everyone, having seen everyone on screen often over the last several months. So here we are on the last session of the day, talking about litigation post-pandemic and the client's perspective. Let's just going to run the poll. So I'm going to sort of defy convention and ask you all to pick up your mobiles rather than to turn them off, to just log on to Slido. I'm sure you've already done it already, because, and if you haven't, then just very quickly. And I just want to let you know that these three in-house counsel are going to be noting who's doing it and who's not. We've just had a discussion about how lawyers keep saying they're not very techie. That doesn't go down well. So just if you can log on to slido.com. And then if you would like to Legal Business, put up the poll. We have this poll that we just thought would be a bit of fun to see how we were all going on. So first question is, do you want to work from home? So those are your options. One of them being, I want to get back to the office and I never want to work from home again in my entire life. So here we are. Interesting. Oh, gosh, so 100% of the time. Great. So let's just call it there for 1 minute. So most 50% of the time. So we've got the hybrid going. And then just the next question. So again, similar question in respect to, do you want to engage in court hearings or mediations remotely? So once again, is that, I just want to get back into the courtroom? Or is it 50% of the time, the hybrid? So again, that looks like, yeah, thanks. Yeah. I thought I'd just do some neck exercises while I was up here. And then the next question, please, Legal Business. So I think so far it's, so metaverse and machine learning technology versus pre-COVID traditional way of working. Where are you on the use of that? So not very techie, interested but in a disinterested way, or interested in skilling up. That's great. Bravo, well done. Well, this panel of GCs already like you. That's good. They're very techie people. Okay. Abby may have something to say to you. And then just the last question, please. So finally, what's taking expertise and price, economic value out of the equation? What's the number one thing that you think clients and GCs look for in their litigators, in their lawyers? So there's a couple of options there for you. And maybe it's just like that psychometric test. You just go for one, read it, and think, yes, that's the one. So, interesting. Okay, so the top one. So no one goes for teamwork. Okay, interesting. I love these polls. They're always so interesting. Okay, well, so segueing on from that last question, and just keeping that up for 1 minute, if you wouldn't mind, Legal Business. So, my esteemed panel, it's a very privileged to be up here with you. As they say, you sit on intelligent people's doorsteps and learn much. What is the number one attribute for all of you, do you think? So, Abby, let's start with you. What do you look for from your external counsel? Because what do your board look to you to provide?
One thing we look for is logic. We look for logic. We look for legal skills, being up to date. Then the board, most times the board wants you to demonstrate relevance, be able to create interactions with the board, and be able to balance issues and the people, and being productive.
So does that mean that the board looks to the team, the team that you run, the general counsel, legal team and they look to the team to provide responsive, on-point,
productive
concise
answers.
advice.
Yeah.
Great, thanks, Zoe. Brian, what's your board, what's your client, external client looking to you to provide?
I'm very happy to see the top response there. I think there are two, we were chatting earlier, there are two things that we hate to hear from our lawyers. One is, and we'll talk about later, I'm a lawyer, I'm not good at tech. All right, we'll come back to that. And the second one is, I'm a lawyer, I'm not good with numbers, I don't need to be. And that is something that would be very foreign to the world that I'm in, certainly, where I have investment committees and CEOs of boards of portfolio companies who just view legal risk as part of the overall risk matrix of the business. There's supply chain risk, there's liquidity risk in finance, and you need to quantify this and be commercial. Of course, you want good lawyers who have skills, and no one voted for excellent analytical skills because we just assume that, right? That's default. But you need to be able to present, crisp, clear advice, and that may be including like pricing uncertainty, rather than a 50-page prospect's opinion. Something simple that our boards can deal with in a PowerPoint presentation, in a decision tree about how this litigation is going to go, because often that's all the time we get as well with our commercial people. But happy to hear other thoughts as well.
And in terms of the decision tree that you mentioned, what kind of tech do you use to produce those decision trees? Do you have a particular system that you use, or?
I think, unfortunately, we're boring and stuck in PowerPoint, but certainly there's a role for it. I mean, I think there often is a lot of paperwork produced on the external counsel side, which I end up having to summarise for a board. And because, of course, you'll attach the legal opinion or the statement of claim, whatever you're up to in the process. Again, I don't think anyone on my side really reads that, apart from perhaps us, I suspect, and our teams. So there's probably a role for that tech to come in and help link that, because I know internally our decision-making processes on other things like supply chain, on dealing with customers, on dealing with any sort of key third-party logistics providers. Our fund owns various retail assets. Before that, I was in BlackRock in financial services. Now it's retail. They have very good tech for dealing with it because they've got just thousands of transactions to deal with. So they analyse things purely on that basis. So there's probably an interesting role for external counsel to plug into that at some point.
Yeah, no, wholly. Because, I mean, after all, isn't it, it was what your internal client wants, what your board want, isn't it, is actually just to know the time. As we discussed earlier, they don't want the history of watchmaking or how you make a clock. They just want to know what the time is.
Exactly.
So the external counsel, I suppose, tend to give the 50 pages because they're giving the history and what the time is. And
because that's what you're dealing with the court or whatever process you're in. That's what I understand that. Yeah. It's just, and to an extent, I think we probably need to understand bits of that too, but then it's the next level of reduction by the time it's to our internal clients. Yeah,
well, we're going to come on in a minute to talk about communication. So maybe one of the things that needs to be spoken about at the beginning, isn't it, is how you want to be communicated with. So Suba, what's your, as the head of litigation at Siemens, what's your number one?
I think the survey there is more or less right. What you have to understand is, in-house lawyers, we are, if you like, the filter between the external legal advice that comes in and what the board wants to achieve. So in a litigation, it's natural the business has got a problem and they're looking for a solution. What they want ultimately is to know what are our options and what is the best option, and how do we engage in doing that. So the analogy used about telling the time and knowing how to build a clock, I think both are needed. I may disagree slightly. I will need to know, well, why is it that you are saying this? I'm surprised it's got 0 for excellent analytical skills, because that's needed to fully understand the issues at a certain depth. But then you have to filter it through and package it and present it to people who are very busy, who can make decisions on that. They don't need to go behind that and say, well, how did you come to this? They need the bullet points. These are our options, and go there. And so the commercial practical advice and good tactician is, I completely agree, probably the most important thing, because that tells them, well, these are your possible solutions and options, and this is how you get there.
Thank you. What I was surprised about, actually, to be honest, is that teamwork gets 0. Because, well, we'll come on, Suba, in a minute to talk about actually what you have seen in terms of litigation in the pandemic and post-pandemic. One of the things that I wanted to discuss about was actually how you get your teams to make good decisions. Because ultimately, are we going to litigate? When are we going to stop litigating? Are we going to mediate? All of those decisions you have to make for the business. And so how you get your internal team and then run your external team to make good decisions. So that's one of the things I wanted to discuss with you. Maybe Abby, coming to you first. How do you make good decisions, particularly given that we've all been working from home, even more difficult to get the team to work as a team, to get that team flow?
Collaboration, working together, teamwork. I'm so surprised it's 0 there. It's teamwork. Setting out meetings, online Zoom, Skype, Microsoft Teams, and feedback. So, teamwork, basically.
Yeah,
That's it.
I agree. I was surprised too. What do you
100%
think?
teamwork.
No teamwork is happening here.
Well, or perhaps they think we don't value teamwork, if the question. It's hard. I don't know if the pandemic and going to Teams and Zoom and Skype and all the hundreds of other things has been that helpful for decision making. It can be quite challenging, certainly. We were chatting before that there are a lot of in those decisions about whether to litigate or to settle, in the same way, if I was looking at M&A transactions, when you're having those aggressive buyer-seller negotiations, in the old school meetings, you could find a side room and have a chat in a corridor about something to make progress. And we're chatting outside that element has gone away, and you have to very proactively bring that up and bring that back. Same for internal discussions. There are often warring factions in our own clients, as you'd expect, sometimes about should we go ahead with this or not, because everything has a reputational and business impact, not just the court process itself. So I'm not sure I necessarily have the answers to this particular one. It's just been challenging. It's something we keep on top of. For overall risk making and decisions going forward, we kind of use risk matrices. So we literally just look at values and percentages and try and quantify these things. And we do like it when external lawyers put their hand up and say, I've been doing this type of work for you for a while, and obviously I'll fight to the death for you, or subject to professional ethics and law and that stuff. But I think you have a problem in this business unit. I think there's a systemic risk here that perhaps isn't being seen. So it's always nice and something I'd value in feedback from external counsel.
Yeah, and I think the key thing about teams, isn't it, is that you have loyal disagreement, isn't it?
Yeah.
You're saying sort of a number of people have different strong opinions, and that's not something that I think to be shut down, is it? Because ultimately, as a litigator, you need to try and see the other person's point of view, isn't it? So that you can actually make sure you shore up your defence or your case as a result of that, rather than just ignoring it. Suba, what do you think about teamwork and how important it is in terms of making a decision?
I think it's absolutely critical. If I can just say this, in fairness to the audience who've done the survey, the question says, what's the number one thing? I don't think we should say that means because they've said 0 to teamwork, everybody thinks teamwork isn't important. I think it's part and parcel of it. It might not be number one. And teamwork, as you've identified, doesn't necessarily mean agreement in anything. Believe me, in a conglomerate, even within your own team, you will have raging battles because people have very different drivers and interests. Certain people on a project will be absolutely focused on delivering the project, irrespective of what scuffles you may want to have. Then the bean counters may be more interested in, well, what's the rate of return, et cetera, and you have to balance out all of those things. So I think it's healthy to have disagreements, but that disagreements doesn't mean it's not teamwork.
Yeah, I was reading the Professor Kahneman book over the weekend, Noise, and it's really interesting. So he was the one that wrote Thinking Fast and Slow, and one of his points is when you're trying to get a good decision, you obviously need a diverse team and a team that's cognitively diverse as well. But the key thing is that in a meeting, the first person who speaks is likely to get the group to agree with their point of view. So if you want a truly diverse discussion, and so you don't just get the person coming to the meeting, normally maybe the leader, the head of the board or the general counsel saying, my view is that we should sue, and everyone all just says, yes, I agree, I think we should sue too, is that there should be, prior to the meeting where you make a decision of that sort, you actually share different views. So everyone thinks for themselves, you then share that, and then you then get the collective diversity of view, the people, Suba, you saying, who violently disagree with something, or the bean counters, as you put it, but you get everyone's view, and then collectively you can see that view and collectively make a decision. Good. Suba, we were going to talk about what you had seen during the pandemic and post-pandemic, i.e. where you predict that there's legal business. You probably can take that off if you want to, or leave it on as it suits you. You were going to talk about what you were seeing post-pandemic and during the pandemic in terms of litigation as head of litigations at Siemens.
Thank you. It's been a strange year, I think, not just for us, probably for everybody, and adapting. So for us, Siemens Energy, who I have moved to, I should say I've been with Siemens 17 years, but according to LinkedIn, only a year, because I moved to Siemens Energy a year ago. The kind of disputes that we've had, a lot of them have related to the effects of COVID, but the business decision has been, look, for this period, let's just try and survive it. Whether our supplier or whether our customers, we are all in this together. We need to park our disputes for the benefit of the project, and we can have our battles later. It's better to try and get through this period, almost fudging a lot of issues, being a lot more accommodating ourselves as well as, let's say, our customers and us towards our suppliers, just to get through things. And there's parallels, if you like, with, for example, the Insolvency Act, if I call it that, the Corporate Insolvency Act that came in last year. That there's a moratorium on these insolvencies. And similar, there's been a moratorium, if you like, on triggering disputes. But what I am seeing is now that the dust is settling, we're sort of thinking and putting on strategies, right? How do we deal with these things that we could have had a spat over for the last 18 months, but we thought, well, let's get through to the next stage. Now the figures, there's enough noughts in there to litigate, and we'll be doing that. I think, so it's been inactive in the sense of actual claims being issued and notices being served, but more a reserve your position, collectively try get through and leave the fight for afterwards, which I think is coming. And the other thing, my prediction within Siemens, is there'll be a lot of insolvency-related litigation that we're bracing ourselves for in the next year, 18 months.
Yes. Abby, how about you, Abby?
We noticed that for contract, a lot of contracts were affected. So there were some things are not inserted in terms for agreement. And we noticed we just had to create new measures for contracts. Then, basically, clients had issues with dealing with them virtually. They wanted to come in to see, they wanted to come into the office, and which we thought was virtual hearing has come to stay, because for disputes, we tried, putting people online, but some didn't turn up. Some did, and the ones that didn't turn up were very upset that we had to create a Zoom. So basically, it was just a new environment for the work mode in the office.
Thanks. Brian?
Yeah, so I think I echo Suba's comments and Abby's as well. I'd say, we certainly utilised the moratorium and other provisions that sort of still stayed a bit of litigation or kept it culturally kind of held back a bit. There was a bit of a let's all pull together attitude, even if those particular provisions weren't relevant to the dispute. which probably means there is a bit of an avalanche coming in the future in terms of that. That said, I agree with the administration comment. We as a fund have done pre-pack administration acquisitions, as well as obviously solvent ones. In retail, I think we'll be looking at Black Friday and Christmas consumer spending figures to see what happens Q1 next year and whether that drives more administrations, more litigations or not. But certainly there was a lot less litigation than I thought there would be during that period, which was interesting. It probably meant there were just lots of angry letters and going around and people not actually taking the next step for a number of reasons. And maybe it's more to come. Well, I guess we'll see.
Yes, absolutely. Talk to me in terms of, we've spoken about all returning to the office, but given that we're, as the poll showed, that we're now living in this hybrid world, which I'm pleased that we are, offers lots of different opportunities, including not having to keep jumping onto planes, which means Greta will be happy with us all. But in terms of, tell me, how do you, Suba, find running virtual meetings? What are your top tips as sort of head of litigation at Siemens? You have to run these virtual meetings with your team, with your external counsel. Have you got some top tips that you can share with us all? Because I do think it is a different skill, isn't it, than actually being just round the table where you can see people, you can see, the body language, you can read it easier. What are your top tips?
Yeah, I mean, if I can just make one confession, I think if I could have voted, I'd be the one desperate to get back into the office. The reason is I have a 7-month-old baby, and trust me, any excuse to get into the office, you would take it. But that doesn't qualify, apparently. I don't think we're ever, I don't know how many of you had heard of Teams. I certainly hadn't before pandemic. It was a new thing. We not done with my colleagues in Munich and Erlangen. We have regular calls. I'd go to Germany once a month, but for the last 18 months I haven't been once. But we have functioned almost as well, if not better, than before. And I think that innovation, that push, nobody's going to put the genie back in the bottle. Full stop. We are not going back to the office full time. Siemens have got a policy now. We only go if you have to. Otherwise, the position is work from home. But there is a cost to that. I think, it's hard work. It's mentally tougher, I find, for my colleagues. And when you have bang, 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 Teams meeting after Teams. And you can never separate, in my view, whether with your opponent in a litigation or with your own side, the professional discussion with the quasi-social discussions that you would have by the water cooler, by the coffee machine and so on, where often a lot of the ice is broken, a lot of progress can be made. And I think Teams prohibits that kind of thing. So it's been very useful. We're not going back. We've managed to function, with the pandemic as well as anybody could. But I still think that over time we will go back at least some way, probably 50% of the way, to the office working, because there's quite a bit lost from an in-person meeting when you're behind a screen.
But given that there is likely to be more hybrid meetings, if some of you are in the office and some of you are not, do you, as the chair of those meetings, do you think it's important that the person that's actually around the meeting table with the others, as the chair, absolutely remembers that there are people on the screen or joining in by telephone? So that's, I think, why I think it actually is a skill, isn't it? Because if you're the chair of the meeting, you have to absolutely positively remember that there's other people on the meeting that you can't see because they're on the telephone, or actually they're on the screen, but you have to remember to look at the screen. Otherwise, they become invisible because they're on mute.
You're right, but there is a feeling of almost being a second-class attendee, if you like. If there's people in a room and you're dialing in, etc., there's always that perception of, well, what else is going on in that meeting room that you're not privy to. Although, for transparency, the cameras will be on and there'll be discussions throughout, but when you take breaks. But it's a skill set that people are developing and will get better at managing. I'm afraid we will carry on, I suspect, with hearings online as well as meetings with opponents.
Yeah, absolutely. Ryan, any top tips as to how you manage a remote meeting?
I think the first question always to ask is, do I need a meeting in the first place? That's one of the key things that often I think we forgot after a couple of months, and it just became meeting fatigue and online meeting fatigue, to those points you're making before about the mental tax it has on people. We've experimented with a few different things. I think one interesting point to take on the issue you were saying about, if you were chairing a meeting and you have your own agenda, will you just drive that through? Everyone sort of nods as second-class attendees, and you have no real debate about that. Is to separate the functionality of chairing a meeting and leadership. That is to have, and even rotate that idea between different lawyers in our team, to chair meetings on topics. That means they can neutrally do that to an extent, with admitting they've still got bosses and internal politics to deal with. And that prevents that sort of top-down drive. That said, when I go to board meetings, it's still pretty top-down drive, and that's an area which you struggle, I think. But within your own hierarchy, I guess you have a chance of trying to create that sort of cultural change. And there's no reason you couldn't do that in in-person meetings, RL meetings as well.
Yeah. Abby, any top tips on how you chair your remote meetings with your team?
I was just a little bit concerned about privacy. It was okay. And one thing I had to do was to maintain a work balance, be available at all times, which I found very difficult because I have a 7-year-old now. It was tasking, and given school was online. So it was okay, but very challenging. And at times when you shut down your video for privacy, it's as if you don't want to be part of the meeting, but it's here to stay, so.
And I think that's one of the things that I was speaking to someone recently who they were in in-house counsel, and they had an actor come to speak to them about how to do remote meetings. And one of the tips, which I actually thought was quite a good one, which I will pass on, was actually when you're chairing a meeting, your point with privacy, is before you then call on someone to speak. So if I'm chairing, I won't just suddenly say, so Abby, what do you think about this? Because Abby, of course, may not be ready. So actually what you will do is, like they do on sort of the news, they cue that they're going to come to Abby in a second. So they sort of will say, I'm going to come to Abby in a couple of minutes just to get her to give us an update on what she was doing last week. But before then, Ryan, I'll come to you after that too. So Abby, and that means that Abby then, if she's doing something that actually she's not camera ready, or just needs to get her mind in gear because her 7-year-old has just spilt water over her laptop, she's just got a couple of minutes to collect her thought before she's on. And I thought that was just a really good practical tip when you're chairing a meeting, to be mindful of those things. So we've got things to learn from the newsreaders, I think. Anything else you wanted to pass on before we move on to another topic? No, great. Okay, well, one of the questions we did ask was in terms of the audience, whether they were techie or not techie. So, and when we were having a quick discussion before we started, all of you said how important it was that you had lawyers who were tech savvy and could talk the talk in terms of the numbers and the tech. So, Ryan, talk a bit more about that. What do you expect? What do you want? How do you see the legal profession will be transformed over the next 10 years?
It's certainly a very good point. For us, we're a digital-first business, so I guess every organisation will be different, but for us it is very important. And it's one of the things that I've observed, I think I was saying to you earlier, when I've seen external counsel talking to our internal clients and saying, like, the old jokes about not going at tech or other things, which is trying, maybe it's a defence mechanism, I don't know, but that kind of upsets our digital people. Like, they don't like that as a partner. So it's about understanding, I think, and making an effort to understand. Of course, the things are complicated. Of course, you're not going to become programmers. All that said, when I was actually working at BlackRock beforehand, they have a new program of making their junior, I guess you call them investment bankers, forcibly learn how to code. you do that for lawyers too. So as an actual thing, so you have to do it. You have to spend some time to learn how to do something like that, just to get yourself out of that. Many of you maybe are very techie, which is fantastic, and we can talk about blockchain and things like that in a second, and smart contracts. But it is a bit of a challenge, I think, to get people who don't have that natural mentality out of it, because it can hurt that internal client relationship. It won't necessarily upset me, but it might certainly our digital marketing team or our coders.
So you'll be happy that everyone in this audience is skilling up.
They seem to like it before, yeah.
Yeah, they're buying Amazon books like no tomorrow in terms of how to code already.
Why not?
So Abby, how about you? So how important do you think your lawyers being tech savvy is?
Very important. Law and technology has become intertwined. Given evidence has become electronic, basically, most evidence. So it's very important. When I hear lawyers saying they're not techie, I don't understand what they're saying, because it's the same approach to your contract and agreement. It's the same thing. So I think it's very important for the legal world. Then talking about taxation, it's an area that is coming up. It's raised concerns over the years, and the regulation, as decided by the OECD, G20, from December this year, will be available. So the digital world, cryptocurrencies will be regulated. Then they need lawyers, so we need to be techie. Because everybody wants to make the money.
Yeah, I read in the Times over the weekend that the New York mayor is taking his first couple of salary checks in Bitcoin.
Okay, yeah.
So, Suba, how about you? Talk to us about tech.
I think I'll speak from a litigation perspective. I mean, within Siemens, there are other actual specific tech businesses, if you like. But from a litigation perspective, I think it's important to have equivalence in terms of technology. So there's no point in having lawyers who are very tech savvy if you can't bring along whether somebody who's not that tech savvy like myself or my commercial colleagues. So it's having the ability to explain the technology that you're using and helping us to adapt and use that along with the external advisors. To answer your question in one sentence, it is important. It's required for efficiency, it's required for cost savings, etc. But I think the added bit is to try and balance out the understanding of that technology, the workings of it, the background of it, between the teams of in-house, our internal client, as well as external advisors, so that you're all aligned at a certain level of technical competence.
And Ryan, talk to us more about the UK Jurisdiction Task Force and the digital rules that were published earlier this year that the Master of the Rolls is promoting. Have you got those in your contracts?
He seemed keen. It is, yeah. It's a direction that is certainly welcomed by us. It's ultimately motivated by efficiency. That's the thing, and that's the thing which I think courts have looked at for a long time in litigation processes. And certainly, there's a role. There's a mixed role, I'd say, but a lot of the virtual hearings and equivalent, mandates for lawyers to use certain systems are important for perhaps making a lot of those ancillary proceedings done more efficiently. I still agree it's hard sometimes for a main case to be done virtually and to have those directions for for digital resolution and for the process going forward. But ultimately, if we can avoid flying to the same place and having to have those meetups in the past, and we can try to think about the use of technology when you have a particular matter, just as a start. Yeah, I think that's the right direction. I generally think it'll take a long time, and going further to things like smart contracts and blockchain is probably, I mean, you could probably survey the room. I suspect almost no one here has dealt with them. I'd love if they had been dealing with them, but it's probably next decade, or maybe it's earlier. I don't know. We're debating outside.
Yeah, but the point is, isn't it, you need to change before you need to.
Yes.
So that's the point of these rules, isn't it, is that it may not yet be frequent, but actually it's coming. And so to have these rules in place, which means that you've got sort of on-chain dispute resolution, is more transformative than just speeding up the process
Yep.
that we already have, i.e. making a faster horse. So just talking about the Master of the Rolls and his vision to transform the justice system, so it's beyond just automating litigation, making it faster. One of the things I know that was spoken about earlier today, and would be interested to get your views, is this the funnel that the Master of the Rolls is designing that all disputes will go into, will have increasingly more and more automated mediation, so intervention. So in terms of your different roles, your different organisations, are you in favour of compulsory mediation, or you want to just constantly keep the discretion as to whether or not? Suba, have a go first.
I mean, I can answer it in this way. In almost all the contracts that we have that are bespoke and written, we will have a form of mediation built in. Which signals to you that it does a lot of useful things, which is it doesn't signal one party is advocating mediation because they think they're weak. It is a contractual requirement in the contract. So whether the court mandates it or not, we as an organisation find value in having that in our contracts. It can take various forms. It can take internal escalation. It can actually have specified mediation bodies. It just depends on the contract. So the short answer is yes.
Pre-action and
yes.
Throughout the whole course of any action as well.
Before you trigger, notice of arbitration or issue a claim, there will be stages. I think it's a balance to be struck between having, lots and lots of hoops before you can pull the trigger, and having a sensible attempt for parties to genuinely try and settle it. So. Where we have that, then the question arises, well, what added value is there subsequently for a court to mandate mediation if we've already been through that process before? Usually these are sensible, commercial, large organisations who won't go to court if they can help it. They're not fighting for principle, generally speaking. So I wouldn't be a fan of compulsory mediation afterwards unless there's a get out to say, well, to the judge that we've had this already.
Done it. Yeah. Abby, what's your thinking?
I won't be a fan of compulsory mediation, although clients prefer mediation, they rather have a mediation than go to court. But depending on what they decide, that's what we'll go for. It saves time, it's good, but it's not about us, it's about the client. But over the years, clients would rather settle for mediation. And I prefer it generally, so I want it to stay.
Thanks, Abby. Brian, what's your views?
So it was an interesting discussion earlier on this topic. I am still on the fence. I think I've seen it use it tactically. I probably use it tactically myself. So I think I'd want to preserve the flexibility to have it. Would I mandate it for everything? Probably not. It'll depend on the types of contract. Like Sid was saying, we write it into a lot of contracts by default. And that may just give people a bit more time to cool off and have it. But I do agree that we generally, we're running things by numbers. We're not fighting on principles of law or general principles. It's just simply that something has occurred, often outside each party's control, as in it wasn't envisaged at the time, and now we have a dispute. For us, it gets the whole dispute process gets priced in to our general reputation and our image as well. Like, it's a big factor for us. So having that ability to have that mediation, if it can solve it, which, the math, someone will know the math of how often it works, is helpful. Because I definitely know, for our perspective, that while we all might be fighting about legal risk and everyone's fighting to help their clients, our boards and our investment committees will probably be more concerned about brand image damage, reputation, and because those are all things to be priced into this equation. And accordingly, if there is a way of using mediation to somewhat lessen that risk of a blowing up, that can be helpful. So it might be that element, and when it's being used in the actual legal sense, I've seen it used more tactically. a pre-discovery or delay process, or that's often the case. And I'm sure that was sort of some of the comments that were echoed on in the earlier session today.
Yeah, that's interesting in terms of just sort of the reputation point that you mentioned there, which is obviously so important, because actually just coming to you, the audience, just have you, a show of hands if you wouldn't mind, do you think increasingly there are more press getting involved in court hearings? Certainly when, just before the pandemic, I was in court a lot, getting lots of injunctions, and there were an awful lot of press constantly coming into sort of the ex parte hearing rooms, and then certainly during the pandemic with the remote hearings, there were increasingly more and more press coming into the remote hearings, and then petitioning the judge for skeletons, for access to evidence, and so on and so forth. So your point that actually I think the remote hearings have allowed the press to become even more able to, quite rightly, to get before the court. We have a system of public justice. But how, in terms of the audience, did you see that sort of trend, a show of hands to say, yes, I definitely saw more press? Lucy, yes, more press being involved. I mean, I had an ex parte Norwich Pharmacal, and literally at the end of the hearing, a journalist sort of spoke up and then said, can I have all the skeletons, et cetera, et cetera. So, and similarly last year, and there it means that you then have to deal with that whole issue, which obviously you've already got a very busy piece of litigation, and now you're having to deal with access to press, public hearings, so on and so forth, which comes back to your point.
It's a strange world. I've seen in previous clients, not my current one, I've seen lawyers texting journalists after meetings, which is, I would have thought, unheard of generally. But now it's part of the general, like your general risk management, including public perception of how litigation is conducted and the image that, because, I mean, any business, no one wants to really be suing customers or suppliers or having employee disputes. It hurts. But these things happen. And for some, that image management is probably maybe more important than some of the substantive issues of the case. Dare I say it?
Now, obviously, the electronic file is all open to the public, so it's much easier, isn't it, to get access to the information. Yeah. Okay, I'm very mindful of time and mindful that I've asked loads of questions that I wanted to ask. So being not selfish for 1 second, can I throw the microphone over to the audience to invite you to ask any question you'd like to ask of this panel?
Yes, we've had a few questions come through for the panel from our Slido app. The first question is, what is the GC perspective on the use of barristers post-pandemic? Is direct access a more attractive option for larger in-house teams?
There we are, panel. Go for it. Super, go first.
I'm not sure if I'll be popular amongst the law firms here when I give this answer, but even pre-pandemic, there's a sizable percentage of my cases that I would do on, I call it direct access, but it's not quite that, is it? If you're a practicing solicitor, it's not technically direct access. But what we mean is without engaging a law firm. And it depends on the case and it depends on the circumstance. So it depends what you're using counsel for. If it's a big arbitration that's going to run 2-3 years, it's absolutely a no-brainer. You will engage a law firm because of the heavy lifting and manpower that you need. If it's something like an interpretation of a contract that you think, well, the dispute hinges on this, then without question I'd get a QC's opinion to do that. So I don't think the pandemic has changed the intention of when we use counsel directly one bit.
Abby?
It depends on the case and it depends on the client. The pandemic hasn't changed anything.
And I'd say I agree the pandemic probably hasn't changed it. I think there was an increasing trend generally before that. Usually for, as I said, specialised matters, I had a point where a case was hinging on some archaic 18th century lien because there wasn't law in the area other than that. And that's the case when you do that. But certainly for just general access to justice and probably for cost reasons, I think there was an increasing trend, but I don't think the pandemic particularly changed that trend.
Okay, thank you. The next question is, we heard earlier about DBAs and funding. However, there are a wealth of options available beyond these two. How well do you feel your external counsel advise you on the options for funding disputes? Do you feel they adequately advise on ATE insurance and managing the downside risk of litigation?
Any of you want to take that? Should I pick on you, Suba, because you're nearest me?
Yeah, that's fine. I mean, this is probably a specific answer from Siemens, and it may not apply to all organisations, but I've always had this conundrum of external funding for cases. If you're a sensible company that's got money, you will only invest it in a litigation that is sensible, that you think you will win. And therefore, the obvious question from my finance director will come, well, isn't it cheaper to go on, whether it's a traditional retainer basis, than pay this chunk of, £100 million dispute to a law firm? And the number crunching will come out and say, well, it'll be cheaper this way. If it's a rubbish case, then I suspect the external funders won't want to touch it in the first place. So, those aren't the ones that you can... And we've had the debate about, well, can you do a portfolio deal with disputes, etc.? It doesn't quite work. But to answer your question, law firms do promote that to their credit. They do explain that these are the options, but the decision is made usually by the finance director in conjunction with in-house legal. And we haven't had the need for funding for our disputes.
Abby, are your external lawyers doing a good job in advising you in this respect?
Somewhat. It really depends on the case, because most times the team could handle it, and if you need external counsel, you get in touch with them. So really, then it depends on the CEO. Then another factor is money available to spend on litigation.
Thanks, Abby. Brian?
I think we take most things on balance sheet, so we take the risks ourselves. I've had the conversation. I will say that law firms remember about AT insurance, but more generally about litigation funding. But generally, we've taken the risk on balance sheet. I've certainly defended against matters before, which have been funded that way, and we've actually approached the funders to convince them they didn't have a reasonable prospect of a financial return, which was quite effective, perhaps more than talking to the lawyers on the other side. But look, maybe it's an area we should consider more. I don't think we just default assume it's a balance sheet risk, and we go ahead ploughing our own capital into it. But we probably should look into it more often.
A good reminder that question was, I think. I think we've reached time, have we?
We have, and there's a few minutes left if there's any more questions from the floor. No? I think that's it. Well, thank you very much, Jane, Suba, Abby and Ryan. Thank you very much.
Pleasure. Thanks very much to you all.